Welcome back to Paralegals Memo. In part 1, talking about patent filings, we talked about how paralegals keep the patent engine running behind the scenes. Today, in part 2, I will break down why inventors turn to the Patent Cooperation Treaty, PCT, after a U.S. filing and what that actually means for global patent protection. I'm an international bilingual paralegal, and the podcast Paralegals Memo is at the intersection of intellectual property, arbitration, and translation, usually in a Latin American context. Be sure to subscribe to Paralegals Memo, the newsletter on LinkedIn at bit.ly/paralegal101, and of course, this podcast wherever you're listening today. Remember, nothing that appears in Paralegals Memo newsletter on LinkedIn or in this podcast is legal advice. The PCT is an international system that lets inventors file once, preserve priority, and buy time to decide where to seek patent protection worldwide. If you're an inventor or founder thinking about protecting an idea beyond the U.S., this episode will help you understand why the PCT exists, how it fits alongside a U.S. filing, and who actually keeps the system working in practice. What's changed recently is that global patent systems are becoming more automated, more interconnected, and far less forgiving. That makes operational precision more important than ever. Let's walk through 10 things to keep in mind when using the PCT to move from a U.S. filing to global patent protection. The PCT is a procedural engine, and paralegals keep it moving. Most international patent strategies start with the U.S. filing at the USPTO, the U.S. Patent Trade Office. In practical terms, the PCT gives you more time to decide where international protection actually makes sense, a single procedural framework to manage early global steps, and early intelligence on patentability before committing to national filings. The PCT does not replace that filing, it builds upon the filing in the U.S. Here's the first thing to understand. The PCT doesn't grant you a patent. The PCT exists because filing separate patent applications in dozens of countries all at once would be expensive, chaotic, and risky. The PCT gives applicants a way to pause the global decision-making process, preserve priority, and keep their options open while they assess markets, funding, and enforcement strategy. For a paralegal, that means managing the early stages with real precision, so the application is clean, complete, and positioned for the global journey ahead. A strong start here makes everything downstream easier. Number 2, priority claims are fragile and protecting them is essential. A priority claim can break over something as small as an incorrect date or a mismatched application name. Paralegals protect that claim by carefully verifying names, entities, signatures, and data across offices. One of the best safeguards today is ePCT, which cross-checks priority data in real time and catches issues before they become permanent. Number 3, the International Search Report is early strategic intelligence, and now it's even stronger. The International Search Report and written opinion provide the first real signal about patentability. Paralegals track when the ISR is issued, organize the cited prior art, flag key issues, and help prepare the ground for amendments. And thanks to the 2026 PCT rule changes, ISRs are now more robust than ever. You have now 19 new national patent collections that were added to the minimum documentation. Non-written disclosures like public demonstrations or oral presentations now count as prior art. And full text data exchanges between offices has replaced image-only PDFs. For founders, this means earlier and clearer insight. For paralegals, it means more data to manage and more responsibility to keep it organized and usable. These early decisions often shape enforcement leverage, licensing discussions, and even disputes or arbitrations years down the line. Number 4, National Phase Entry is a full project management event. At 30 or 31 months, the PCT application splits into national filings. Each country brings its own forms, fees, translations, local agents, and procedural rules. For many founders, this is the point where cost and complexity suddenly feel very real. Paralegals manage this transition so filings stay coordinated and nothing slips through the cracks. Without that project management layer, national phase entry becomes chaotic. Number 5, the PCT timeline is unforgiving, and someone must guard it. One of the most important things to understand about the PCT is that its timeline is not flexible. The key milestones are set by treaty, and once they pass, there's often no meaningful way to recover lost rights. Under the PCT, everything starts with a 12-month priority deadline, which is measured from the earliest filing, usually a U.S. application. Missing that window can sever priorities entirely. Around 16 months, the International Search Report is issued. This is the first substantive signal about patentability and often shapes how applicants think about amendments, budgeting, and where protection is worth pursuing. By 22 months, applicants may request optional international preliminary examination, which can help clarify issues before entering the national phase and position the case more favorably for later prosecution. Then, at 30 or 31 months, the case reaches the national phase entry. At this point, the single PCT application splinters into individual country filings, each with its own fees, forms, translations, and local rules. Paralegals play a critical role by diligently tracking each milestone and catching missed dates that could derail patent rights. Number 6, names and assignments matter more than people think. If applicant names aren't consistent across filings, or if assignments aren't properly recorded, you can lose priority or face defects during the national phase entry. Paralegals ensure consistency across the priority application, the PCT request, declarations, assignments, and national forms. Clean ownership records today prevent expensive fixes later. Number 7, not all ISAs are equal, and choosing one is strategic. International searching authorities differ in speed, quality, cost, language coverage, and examiner approach. Paralegals help attorneys evaluate which ISA best fits the client's goals. Depending on the applicant's citizenship or residence, even the choice of the receiving office, whether the USPTO or WIPO, can affect which ISAs are available. The 2026 updates also raise minimum ISA qualification standards, making this choice more strategic than ever. Number 8, PCT rules evolve and staying current protects your rights. The PCT system changes constantly. The 2026 updates alone touched on minimum documentation requirements, definitions of prior art, full text data exchange, and ISA qualification standards. Paralegals track these changes so filings stay aligned with current practice. As AI-assisted search and examination tools become more common, consistency and completeness in the underlying data matter even more. This is about system integrity, the same theme we discussed in part 1 in the previous episode. Number 9, the PCT is a communication system and paralegals run it. Global filings require constant coordination. Foreign agents, translations, document uploads, fee payments, corrections, and certified copies. Smooth communication is half the battle, and this is where paralegals really shine. Clear coordination reduces delays, confusion, and unnecessary costs. And finally, number 10, a well-organized PCT file saves thousands later. A messy PCT file leads to inconsistent claims, missing documents, late translations, and avoidable attorney time. A clean PCT file reduces friction when the cases enter the national phase and saves real money. And if the ISR is favorable, the PCT Patent Prosecution Highway Program, now extended through 2029, can accelerate examinations in major patent offices worldwide. Paralegals help position cases so applicants can actually take advantage of that opportunity. So if you're an inventor or founder thinking about filing internationally, here's the takeaway. Your attorney defines the legal strategy. The PCT determines whether that strategy survives contact with reality. And it's operational discipline carried day to day by paralegals that turns global patent rights from theory into something enforceable. Thanks for spending this time with me as we explore intellectual property, arbitration, and translation from a bilingual paralegal's perspective. This podcast is informational only and should not be construed as legal advice. Always consult a qualified attorney for your own particular case for guidance. I'm Whitfield Trevette II, a bilingual paralegal, and I'll see you in the next episode.